All right, we got a couple minutes past the hour. People keep filing in, so we'll let the stragglers come in when they can. So, hello everyone. Thank you for joining us for this virtual town hall meeting. My name is Tim Burch. I'm the Executive Director of NSPS, and we've got two esteemed guests today to tell us a little bit more about this whole ordeal of the Davis-Bacon regulations revision. Two distinguished members of the Miller-Windhold Capital Strategies, Mr. John Palatiello, and John JB Byrd are here today to really kind of walk through some things. So John's got the PowerPoint all queued up, and you know what, John? Let's just turn it over to you, and where should we go with this?
Well, thank you, Tim. Good afternoon to everyone. I appreciate everyone participating today. This is a critical issue for NSPS and the surveying profession, so I'm delighted that so many of you have taken the time to join us today and get a little bit more detail about what this issue is all about. So I'm going to jump right into a very brief presentation to kind of give you an overview of what the law and regulations are, what the issue is at hand, what the NSPS position is, and then how individual surveyors, state surveying societies, and other stakeholders can become engaged, involved, and effective in our advocacy. Sorry, I muted myself accidentally. So first of all, we have an entire archive of information about the Davis-Bacon Act on the NSPS website. You can go directly to the URL that's up here, which is nsps.us.com/page/Davis-Bacon. Or if you go to nsps.us.com and then click on advocacy, there'll be a drop down, click on government affairs, there'll be a drop down, click on special issues, and then click on Davis-Bacon, and it'll take you to that page. And the current proposal is on there. The podcast that Tim and I recorded a few days ago is on there. All the background on the previous iterations of this issue are on there, and literally an entire library on this issue. So I would commend that to your attention as a further resource. And Tim, I would expect that we'll be able to post the link to the archive of this town hall and this PowerPoint up there as well. There we go. So, just by way of background to understand what this issue is. Davis-Bacon Act is a law. It's a federal law enacted in 1931, and it has been amended a few times since then. The law is found in Title 40 of the United States Code, and then Section 3141 and the subsequent provisions or sections. Most everything in this PowerPoint that's underlined is hyperlinked. So when you get this after this town hall, you'll be able to click on it. It'll bring you to the actual documents to which I'm referring. The current issue before us today is that the Wage and Hour Division, which is an office within the U.S. Department of Labor, has proposed revisions to the regulations that implement the law. So we're not talking about legislation before Congress. We're talking about revisions to existing regulations implementing a law that has been on the books since 1931. So on March 11th, the Wage and Hour Division of the Department of Labor issued a notice of proposed rulemaking. It's actually called Updating the Davis-Bacon and Related Acts Regulations. And This notice of proposed rule is a link to the actual notice that you will be able to read. The current regulations that the proposal, or the existing regulations that the current proposal is seeking to amend and revise, is found in Title 29 of the Code of Federal Regulations, Parts 1, 3, and 5. And again, that is linked from this presentation. So as I said, the Department of Labor is seeking public comments on proposed rule changes. Comments are due a week from today, next Tuesday, May the 17th. You could submit comments by going to www.regulations.gov, and there'll be a template form there for you to fill in your comments, your name, and other pertinent information. And in the subject line, you should cite Regulatory Information Number, or RIN 1235-AA40. That's this specific rule. Now, what is the Davis-Bacon Act? It is a law that requires the payment of the, quote, prevailing wage, and that's a quote right from the law, to a class of workers called laborers and mechanics, quote unquote, on all federally funded contracts for construction, alteration, or repair, including painting and decorating. Now, the key to that sentence is all federally funded. So if you are working on a project for a new road, and there are federal funds, like from the infrastructure bill that passed not long ago, and your client is your city or your county, but there's federal funds involved, this federal law, the Davis-Bacon Act, flows down with that money. So the law would apply to this particular project. The law says construction, alteration, or repair, including painting and decorating. It's actually much broader than that, but it is a variety of activities directly related to construction, whether it's new or a renovation. So it's construction project, federally funded. Now, the Act and its current regulations and the proposed rules only apply to, in our case, in what we're interested in, members of survey crews. It's important that everyone understand that it has never been the case, nor is it proposed here, to cover licensed surveyors or even party chiefs. We're talking about what traditionally were called rodman, chainman, instrument persons, and so on. And I know I'm even dating myself with some of those terms. But you get the idea of the level of a member of a survey crew that we're talking about here. And we'll discuss that in a little bit more detail as we go along. Now, it's important to point out that even though the Davis-Bacon Act was originally enacted in 1931, there had always been a question about the extent to which it might apply to survey crews. And as a result of that question, in 1962, there were a group of surveyors, I believe the Ohio Surveyors, the Missouri Surveyors, perhaps others, wrote to the Department of Labor and asked for clarification. And a landmark letter was written by then Secretary of Labor Arthur Goldberg. This was in the administration of John F. Kennedy. Interesting sort of historic sidelight. Arthur Goldberg later became a Supreme Court justice. But he wrote a letter, and again, it's linked here from his name on this slide, in which he very, very narrowly determined to whom in a surveying context the Davis-Bacon Act applies. And what he said was that it applies to members of survey crews only to the extent they are, quote, clearing brush and sharpening stakes, unquote. And again, I'll come back to that in a moment. The proposed rules that are out for comment today suggest a new standard to more broadly apply to members of survey crews and more broadly define survey crew personnel as, quote, laborers and mechanics subject to the act, where they would have to be paid the government mandated prevailing wages and fringe benefits for their employment for the time they spend working on a Davis-Bacon applicable contract. The bottom bullet on my slide here is right out of the Federal Register. It's the actual publication of the proposed rule, and it spells out the standard that is now proposed to be applied. I'm quoting directly from the proposed rule. The department has historically recognized that members of survey crews who perform primarily physical and/or manual work on a Davis-Bacon Act or related acts covered project on the site of the work immediately prior to or during construction in support of construction crews may be laborers or mechanics subject to Davis-Bacon Act labor standards, unquote. This is a quote right out of the proposed rule. This is a patently untrue statement. This is absolutely a new opinion by the staff of the Department of Labor. And this is a standard that has not been historically recognized. Again, Secretary Goldberg noted that the physical and manual work of survey crews, such as clearing brush and sharpening stakes, are, quote, not commonplace. This new standard suggests that it is commonplace. So the proposed rule blatantly misrepresents the history and the standard by which members of survey crews would be covered under the Act, and creates a new and unprecedented standard. And in the Federal Register notice, in the proposed regulations, it doesn't even mention the standard established by Secretary Goldberg in 1962. So a couple of things to point out. This does not apply to boundary surveying. It does not apply to topographic surveying. We're really talking only about construction stakeout surveying. That surveying which is directly in support of actual construction as we would normally and traditionally define that term. Now, before I move on, there are two important points that I want to make here. One is a question often comes up, well, why are we opposed to this? Why would we be opposed to higher rates of pay for members of survey crews? And the answer is we're not. What we are opposed to is a very complex, bureaucratic, government-mandated wage rate that the implementation of the Davis-Bacon Act has shown does not necessarily reflect the prevailing wage in a locality in an accurate manner. The proposed rule that we're talking about today is more than 400 pages of changes. And a lot of it has to do with trying to reform the methodology that the Labor Department uses to determine what is the local prevailing wage. So this law has been on the books for 90 years now, and the Labor Department still cannot accurately and properly implement it and come up with reasonable and accurate wage surveys to promulgate the wage rates on the law. So the question is, should the market be determining the wage rates? Should supply and demand be determining wage rates? Should other economic factors determine the wage rates, or should a government mandate determine the wage rates? And we've come down on the side of the market rather than the government. The other reason why NSPS is opposed to this proposal and expanding coverage of Davis-Bacon to survey crews is defining our survey crews as laborers and mechanics is not only demeaning, but it's quite frankly inaccurate. And I'll expand upon that a little bit. There are other government classifications, government documents, reference materials, publications, classifications that define different occupations. Some of them, the Occupational Employment Statistics, the Occupational Outlook Handbook, the Occupational Information Network, those are all Department of Labor products. None of them define members of survey crews as laborers and mechanics. The Federal Office of Personnel Management has what they call qualification standards, position classification standards for every occupation for which there are employees of the federal government, federal workers on the federal payroll. The standard for a GS 817 surveying technician is well above that of a laborer or mechanic. So what the Labor Department is trying to do in this rulemaking is not only unprecedented from a historic standpoint and a deviation from what Secretary Goldberg established 60 years ago, but it is inconsistent with every other federal definition and classification of a member of a survey crew. It is important to point out that there has been no legislation, no court ruling, no Comptroller General decision, that's the Government Accountability Office, no other government action that has changed Secretary Goldberg's interpretation. I would argue that what the Labor Department is trying to do here falls under what lawyers call arbitrary and capricious. There is no basis for what the Labor Department is trying to do here. In fact, as many of you know, many states have a mini Davis-Bacon Act, so that even if there is publicly funded construction in your locality or your state that does not include federal funds, many states have what are called mini Davis-Bacon Acts. There is actually some precedent that's on those state laws that support the NSPS position. In Connecticut, there was a case of James Fazzino versus the State of Connecticut Department of Labor that was decided back in 2010. In it, the court ruled that survey crew members are not subject to the Connecticut State Mini Davis-Bacon Act. What did the court use as evidence to reach that decision? Secretary Goldberg's letter. It's cited right in this decision. The Indiana Department of Transportation issued an opinion in 2007 on a similar question. To what extent does the state Davis-Bacon Act apply to survey crews? The department ruled that it does not apply to survey crews, except to the extent that they are clearing brush or sharpening stakes, quoting and citing Secretary Goldberg's letter. So think for a moment of what construction stakeout is. Remember, Davis-Bacon applies to work that a worker does that is more physical and manual in labor. Activities of a worker that are more judgment and intellectual in nature are exempt. That's why a licensed surveyor is exempt. That's why a party chief is exempt. They are more in a managerial, administrative, professional, supervisory, intellectual, and judgment-oriented position. Construction stakeout, as Tim has taught me, is when you take an engineering plan for a facility, a structure, a road, a building. And a construction stakeout crew's job is to go out and stake out, here's where the sidewalk will be. Here's where the limits of clearing and grading will be. Here's where the building footprint will be. Here's where the water and sewer line will be. Well, in that task, what your crews do, 1% of it is pounding stakes in the ground. That's manual and physical. 99% is analysis and making a determination on where to put the stakes in the ground. So, consistent with Secretary Goldberg's comment about clearing brush and sharpening stakes, the work of survey crews does not belong under this act. In fact, with the way automation and technology and instrumentation have evolved over the last 60 years, you could make the case that construction stakeout was more labor intensive back in Secretary Goldberg's day in 1962 than it is today. So the fundamental reason why we're opposed to this proposed regulation is it really is a fish out of water. It really does not appropriately apply to members of survey crews. So we are in a period now where the Department of Labor is soliciting public comment. They have to be filed by next Tuesday, May 17th, as I mentioned a little earlier. Go to www.regulations.gov and cite the case number, again, as I mentioned before. In developing your comments, and I'm going to put together some bullet points that you may want to use in your comments, and we will have that on the NSPS website in the next day or so. But here are some things that you might want to include in your comment. We would rather not have a lot of form letters. We'd rather have original thoughts from our members, but if there's a consistent theme to surveyors' comments, that's fine. Some of the do's. Do cite the Goldberg precedent, that is the standard by which application of the Davis-Bacon Act should apply. Comment that the rule fails to recognize the reality of surveying and the activity of survey crews, as I just discussed about construction stakeout, and that surveying today, and particularly the work of survey crews, is not manual or physical in nature, but much more requiring judgment and an intellectual exercise. Cite the Indiana and Connecticut precedents that I mentioned before, that this is very much settled, that the standard set by Secretary Goldberg has been followed and adhered to and emulated by others over the course of time. You should also comment, particularly if you are the principal owner or partner or owner of a surveying firm, that this will impose a heavy administrative burden on your firm, on whomever in your firm does your payroll. 99% of surveying firms in America are small business. This is an extraordinary mandate on your firm. It's going to be very costly for you to comply with this, to not only figure out whether a particular contract it falls under the Davis-Bacon Act or doesn't, but also just management of your payroll. Because the problem that we've had with the Davis-Bacon Act is that the prevailing rate that you would get from the Department of Labor is way out of whack with what you normally pay. So you're going to have to pay your crews one rate on Monday if they're working on a federally funded project, and another rate on Tuesday if they're working on something where the funding source is other than the federal government. That is an administrative and payroll management nightmare for small businesses. here are some things that we would recommend that you not bring into the discussion, into your comments. The Davis-Bacon Act is very strongly supported by labor unions. In this political climate, with this political team at the Department of Labor, in this administration, I would not even mention labor unions in your comments, and certainly don't bash the unions or talk about how surveying should not be subject to unionization. Those all may be very valid thoughts that you have. This is not the time or place to articulate them, please. The reason why I made the distinction about what in surveying the Davis-Bacon Act and these proposed rules may apply to or not apply to on who is a survey crew member and who is not. Don't be confused, and I've received some emails on this, and I've needed to help clarify for people. Don't confuse this issue on the difference between a licensed professional or the role of a state licensing board and a technician that does not carry a license. Focus your comments on the technicians, on the survey crews, as distinct from a licensed professional. Finally, don't make political comments, whether you like this administration or don't like this administration, whether you like Trump or don't like Trump. This is not the time or place for those kinds of comments either. Keep it focused on the specifics of the particular proposed rules and the impact on surveying. With that, I didn't want to spend a whole lot of time. I want to give you a brief introduction and overview. And at this point, I'd be happy, Tim, to open it to questions and try to help our members and respond in any way that I can.
All right. If you have questions, go ahead and throw them in the question box. The first one comes from our esteemed colleague, Mr. Ed O'Brien from Rhode Island. It says, could you also explain the relationship between Davis-Bacon and the Brooks Act, and if there's going to be anything that could possibly relate to QBS with the ramifications of these changes in Davis-Bacon?
Ed, thank you for that question. Before I go on, I just want, because I see his thumbnail up there, John Byrd, our registered lobbyist from our firm, is on with us as well. JB's here as a resource and for support. This Davis-Bacon actually happens to be an issue more in my expertise. Those of you who know me know I started my career with the surveying profession on the staff of ACSM back in the 1980s. So I've lived with this for 40 years now. So, but JB's here for support. In response to Ed's question, no, Ed, there really isn't a relationship between the two. The Brooks Act is a method of procurement. It is qualifications-based selection. It really has nothing to do with pay scales or the Davis-Bacon Act. They're two very separate and distinct laws, and one does not impact the other. And this particular rulemaking process, I don't see having any effect or even a precedent that would in any way harm or threaten the Brooks Act. So thanks for that question. That is an important clarification.
All right. Any other questions out there? Let's see. Chris Donahue, yes, this will be published. The video will be published. We'll get it up, and along with the PowerPoint will be posted. John, you want to roll back to that? Can you roll back to that one slide with the address on it? It's on the NSPS website, but that specific page that it's going to be on. There we go, nsps.us.com/page/Davis-Bacon. The recording and the PowerPoint will be on there. Like I said, John's putting together some talking points. We'll have those put together because we've got to compile all of this to go into basically our response back to the Department of Labor by, like he said, Tuesday of last week. The questions are rolling in now.
And these particular resources will be right at the top of the page because we're running them on there, Tim, pretty much chronologically from the most current moving backwards.
Okay, this next question is really coming to semantics. It says, can you help make a distinction between surveying and construction staking?
Well, that's a better question for you than for me, Tim. This is where I get to say I'm not a surveyor. I'm just playing one on the screen.
Oh, you bet, you bet. Well, and I guess it really comes down to when you were saying strictly construction staking, I guess everybody has their own little levels of what really constitutes construction staking. If we're working off a set of plans, if we're working off of an engineering design, and it's based upon either a center line, property lines, I mean, it's geospatially based, then it is construction staking, but it really falls under the direction of a surveyor. So because it has something to do with installation of improvements and development, that's where they're going to really hang in and say, that's the part of this is construction staking, because we are directing an installation of an improvement versus just strictly surveying, obviously boundaries, topos, and mapping, like John said earlier. Hopefully that to me that will cover that up.
Tim, the only thing I would add to that is, I think the very simple thing is that surveyors answer the question where. And even in construction stakeout, you're providing an answer to the question of where.
Sure, that makes sense. Next question is, do you suggest we as individual state associations also send letters, send comments in to the Department of Labor?
Yes.
Absolutely.
Both individual surveyors, and if we can get all 50 state societies to submit a comment, that would be awesome. Very helpful to the cause.
Right. If this passes, how are prevailing wages typically determined?
With a Ouija board. That has been a big issue with this law. The regulations go through quite an extensive process. The Labor Department will accept any information that can be submitted to them. If your state society does wage and salary surveys, you can submit that. They will look at that. They will look at other outside information. They do get data from labor unions. Now, as somebody correct me if I'm wrong, but there's only about 4 states in the United States where survey personnel are even organized under labor unions. So by and large, 95% of the surveying population in America is not part of a union. And then when all else fails, the Labor Department will actually go out and do wage surveys, quote unquote, to try to determine what is the prevailing rate. But again, that has been a very imprecise science. It has been very controversial. And very often they just default to the union wage and not a true market or prevailing wage. And that's what makes this so controversial. It's what, when you think about that process and applying it to actual construction workers, this is why this law has been known to greatly inflate the cost of federally funded construction. And there are a number of very reputable groups, including like the Congressional Budget Office and the Government Accountability Office, that support repeal of the Davis-Bacon Act because they believe it is terribly antiquated and very poorly administered.
Well, there's a comment in here. I think I wanted not really much of a question. It says construction staking in California must must be done under the responsible charge of a land surveyor. And I know that's the case in a lot of states, but I don't think it really necessarily gets carried over once you get on a job site. A lot of times that doesn't matter.
No, and there would not be a wage determination for the licensed surveyor. It would be for the personnel working under the responsible charge of the surveyor.
Okay. Comments will be to this PowerPoint. We'll have this in the video that you'll be able to catch up on. We'll see if we can.
And I can send it to you separately, Tim, so that the PowerPoint, independent of the video, is available.
Yes. Yes.
You already have it. I sent it to you earlier today.
Yep, we'll get that.
Yes.
Says, can we get a copy of the letter that was sent to the Department of Labor from Local 12? So anything that somebody from the other side has sent from organized labor, can we get a copy of what they're saying on the pro side of all of this?
I believe, I've not checked this, two answers to that question, Tim. Number one, I believe if you go to regulations.gov and look for this item, all of the comments that have been filed are posted. So you can see what others have said. There are 8,000 comments on there already, mostly generated by the unions. Secondly, and I didn't want to get into a long discussion, but just to refresh everybody's memory, the Obama Labor Department tried to do this, if everybody will remember AAM 212. The Obama administration tried to make this change with no public comment, no public hearing, no economic analysis, no small business impact, no compliance with laws like the Administrative Procedures Act. We filed a Freedom of Information Act request and got the letters that the Operating Engineers Union submitted to the Obama administration to get that AAM going back in, I think it was 2013. We have that documentation up on this NSPS website. You'll recall that at the waning days of the Trump administration repealed the AAM that the Obama administration had earlier promulgated. This is now an effort to try it again, but through the normal rulemaking process rather than an all-agency memorandum or an AAM. So this is following the more proper procedure for rulemaking. It still doesn't make it right or accurate, but procedurally it's more the way they should be doing these things. But we do know what the unions have been saying about this, and we do have that documentation on the NSPS website.
Hey, Tim, let me interject, John, real quick on the level of transparency about getting certain letters and folks that have gone on the record. John definitely highlighted the fact that NSPS has its own version of a specialty page on this issue where you can click on and find all sorts of documentation. And what I wanted to point out is what the SBA Office of Advocacy has done on this issue to help, make sure that small business perspective is leveraged on this.
SBA is the Small Business Administration.
Yep, on the website, there's a 6-page document that SBA has put together, and on page 5, they have a specific carve-out for our angle on this. And this dates back to about 2017, and what SBA did back then is they actually went around the country and hosted small targeted roundtables where small businessmen and women could take part. NSPS provided talking points to certain areas where we knew these roundtables were going to be taking place, and we provided our members talking points to show up and talk about what John just said, which was AAM 212 and the reason to push back. Even dating back to 2013, Kurt Sumner, then Executive Director of NSPS, was brought in to testify before the House Committee on Education and Workforce, what's now known as Education and Labor Committee in the House. So the NSPS voice has definitely been heard, we think, to help kind of counterbalance what the unions have done on this. However, the other thing that we're working on is that the goal, of course, this roundtable is to make sure that each state society and individual rank and file member of NSPS, if you will, can go on the record. We're happy to say that NSPS is leading the charge on bringing together our friends in the trade association and professional society community to go to bat and to amplify the NSPS voice. So we've already received commitments from American Society of Civil Engineers, ASCE, that they're going to help us out. The Associated Builders and Contractors, ABC, they're going to be helping us out. The Independent Electrical Contractors, IEC, they're going to be helping us out. The Construction Management Association of America, CMAA, they're going to be helping us out. And of course, NSPS. There are several other organizations that co-signed a similar coalition letter back in 2018. And we have additional 3 or 4 that we're pursuing right now. So theoretically, what would happen for everyone that's on the call today is that when you file your individual comment, or if your state society provides that individual comment in the close of business May 17th, next Tuesday, is that through a coalition network, NSPS is leading the charge with a public comment, but from all these different professional societies and trade associations that we typically work in a coalition manner inside the Beltway in Washington, D.C. So we are trying to tackle this on parallel tracks, Tim.
Very good. All right, let me see where I left off here. Should we mention that new technology has made construction staking even more intellectual in nature versus our predecessors?
Yes, that's a very important, very good point to make. And the other point is that, in 1962, we generally had 4, 5, 6 person crews. Today, you may have as little as a 1-person crew. Now, that person obviously is employing a lot of intellectual capacity, a lot of analytical skills. It is much more of an intellectual exercise today because of the automation and the fewer number of members of a survey crew than there were even when Secretary Goldberg issued his opinion in 1962. So yes, the advent and the revolution in automation is an important part of the way the surveying workforce has changed. Okay,
so if I won't say the name of the Golden Arches restaurant is paying $21 an hour, how do you recommend paying our workers a living wage? I mean, this is something we've battled with a lot. Here's an opportunity to raise wages, but we're against it because of like you said, because of the control. Any thoughts on how we get a better message out about what our role is in protecting the public and doing this work and raising those wages?
Well, first of all, Tim, this is the problem with what the Labor Department has done. There's never been any evidence that says that members of survey crews are paid substandard wages. There's just never been any study or any evidence to that effect. Number 2, when you look at the Labor Department, the Bureau of Labor Statistics' own data on what the average salary, average income of a survey crew, a survey technician is in the United States, it's in the upper half of incomes of all American workers. So this is kind of, if it ain't broke, don't fix it. There's nothing that says that the compensation levels that the private supply and demand market is providing is inadequate.
Okie doke. Let's see. Will there be some sample emails or a sample of the most talking points letters that we can pull from just to make it a little easier to get a message back to the Department of Labor?
Yes, we will have that up within the next 24 or 48 hours on the NSPS website. Again, I'd rather not have 100 surveyors submitting a form letter. That's less effective, but we will give you talking points that you can use to put into your own original message.
Okay. Let's see. Since surveying is a subset of professional engineering in the U.S. Code, would this not exempt us? And does Davis-Bacon affect engineering paraprofessionals?
There is not a proposal in this rulemaking to try to extend the Davis-Bacon Act to different classes of engineering technicians. Sort of, I guess the one class that they're going after are survey technicians, because survey technicians are much more on site during the construction process, where an engineering technician might be on site prior to construction. So I think that's where that distinction is.
Okay.
And again, the PE is not covered under this act. The LS is not covered under this act or the regulations. It's the technician level personnel working in support of the PE or LS that they're trying to cover.
Okay. With some of the confusion that the Act has or will affect surveyors, will the results of this proposed change be sent out to all states and their societies? Know that some companies are using prevailing wages and some are not. Becomes a sticking point when interviewing potential employees.
Yes, if this final rule goes through and it is not changed as a result of our comments, NSPS will certainly make that final rule available to all of its members.
Okay. Let's see, kind of running together here. If you're on a construction site and the licensed surveyor is setting the stakes and the other one's running the instrument, and doing some of the technical surveying, would this whole labor thing kick in with Davis-Bacon?
That's a great question. I don't know how common a practice that may be. I really can't give you a definitive answer because the applicability of the Davis-Bacon Act is what is the nature. It's a two-pronged test, essentially. What is the nature of the tasks being performed, and what is the sort of the employment classification of the individual in question? So if you actually have an LS who's pounding stakes, that sort of confuses the issue. I would argue that the answer is no, because even in that scenario, the physical pounding of stakes is a very small percentage of what that licensed surveyor is doing on the site. Again, it's 1%. The physical labor of pounding a stake in the ground. The judgment of where the stakes go is more what every member of the crew is doing, regardless of whether they're licensed professional or not. And that's where I think we can make the argument that that members of survey crews at any level do not fall within the definition of the term laborer and mechanic.
Okay. I think this is pretty easy question. What's the operating engineer's stance?
They have long been advocates for this kind of change.
Okay.
And quite frankly, I believe, Tim, based on my review of the comments and the history of this, I truly believe that the operating engineers are promoting this so that they can go out and use it as a marketing tool to go out and organize more surveying firms as part of labor unions. They can go out and to the workers and say, look what we got for you. So I think this is all about a union organizing tool, and they're not thinking through how is the image of the surveyor being harmed? How is the well-being of the individual survey crew member being adversely impacted from the standpoint of their job classification, their marketability in the job market, and so on?
Let's see. Shall the DOTs, should they offer a letter as well? I mean, is this something that they should reach out to the Department of Labor to comment on as well?
Yes, any of our members, any of those who are on this this session that work for a government agency at any level, we would encourage, if you're authorized to do so, to submit comments, particularly because this is going to unnecessarily inflate the cost of your projects. So that would be very helpful commentary if those agencies can submit comments.
Next one is if this passes, when do we think the regulations would be implemented? And two, and I think this is more, well, you know what, go ahead and do that one first. When do you think this would be implemented if it were to pass?
I would say, JB, what do you think? I mean, I would say 6 months to a year. I mean, it's going to take some time. They've already gotten 8,000 comments. They do actually have to read them all. They have to write the final review. When they publish the final review, they've got to comment on what they heard from the public and why they implemented that suggestion or didn't implement a suggestion in the comments. So it will take some time for this to go through that internal process at the Labor Department. So I would say, optimistically, from their standpoint, it'd be 6 to 8 months to a year. I mean, this is not something that's going to be taking effect in 30 or 60 days by any means.
And on that, John participated, Tim, back on April 25th at the Small Business Roundtable, where the actual wage and hour division employees that are the ones trying to either get their hands around the comments or learn more from the small business community, what kind of feedback, positive or negative, that they're hoping to hear from. At no point did they bring up a timeline as far as when this would go into effect. And to John's point, I think they're just going to get inundated by comments, and that's just going to help delay, if you will, the actual timeline from kicking in as early as they would probably prefer it to go. But those are the career employees, and there may be one or two political appointees that may be added to the mix by the time that the order or the review is completed. So there could actually be some delays internally based on how quickly some of the political appointees still need to be moved through the Senate confirmation process.
So Tim, I would just say this. The final rule on this will be implemented before the November 2024 election, because this is very political and the Biden administration will want this in place before they potentially leave office for another administration.
Okay. The second part of that question was, if it does, if it does pass, would this include travel time to and from the job? And I'll answer that one. And I think, that comes down to between the employer and the employee. I think that condition applies now to whether or not what an employer wants to consider you to be on the clock. So
Tim, I would recommend that individual read. I'm sorry to put you through it. You've got to go through the 400 pages. There is some discussion of that in the proposed rule, because there are some delivery of material, like construction materials, that is under discussion in this rule. I read through the entire rule. I can't cite line and verse everything that I read because I was really looking at it to focus specifically on surveying. But I would, even if it is not part of what you comment upon, just for your own edification, an individual who has an interest in that question should read through the rule or put it into a PDF so you can keyword search it and put in the word travel or delivery, and that'll take you to the sections that includes that discussion.
Okay, another question says, for certain members that are doing the technical side, isn't the prevailing wage based upon, couldn't it be based upon both an average or somewhere in the middle between a union wage and the federal wage, kind of a hybrid? That's the first I've heard of that type of a situation, but we'll ask you.
Again, the rule spends a lot of time talking about the wage survey methodology and how they arrive at the prevailing rate. And it's not an exact science. So the other thing that's interesting is when we were in this period between the Obama AAM and then when it was repealed by Trump, I was hearing from a lot of survey firms that were saying the Labor Department was not even promulgating a wage rate for survey crews. They were lumping them under a general construction helper category. And in many cases, that's way more than what a survey crew typically is paid, but it really was not relevant to the project and the tasks at hand. So it just that, I'm not using that example to talk about the adequacy of compensation of survey crews. I'm making that comment to show the inadequacy of the methodology used by the Department of Labor. You think about every federally funded construction project in America. It's billions of dollars worth of work a year. And then the Labor Department has to come up with prevailing wage rates for every imaginable class of worker covered by the Davis-Bacon Act in that locality, which would be in that county, in that 3-county area, and so on. It is an enormous task. And frankly, the Wage and Hour Division of the Labor Department doesn't have the staff to do that. So that's why there's such imprecision in how they conduct these, quote, wage surveys, unquote.
Okay. This particular question is coming from a project manager, and they're not providing layout services or construction staking per se, but they are providing pre-project QA/QC for checking control, checking benchmarks, or independent checks on somebody else's work for layout. Because they're working around a set of construction plans, do you think this would be something that would be applied to a Davis-Bacon situation?
Potentially. I I would hazard to guess that we will probably see, if this goes through as proposed, what they have in this regulation is rather vague. And after they go through this notice of proposed rulemaking and public comment and a final rule, I would expect that the Labor Department is going to come out with some supplementary documentation, maybe another AAM, that will go into more detail on what's covered and what's not. And that's not a good process. So I apologize for being evasive in answering that question, but we really don't know at this point. But I would expect that if this proposal goes through, it's going to create more confusion than it will answer questions. And it will require further guidance by the Wage and Hour Division.
Sure.
And to what extent we can comment or have input on that is anybody's guess.
Okay. California has an operating engineers union that includes surveyors if the firm is signatory. If surveyors are not subject to the Davis-Bacon wage requirements on a federally funded project, how can you address how the potential that other trades in construction would be paid higher wages than the surveyors, i.e. the grade checker would be working for the grading contractor and could be paid substantially higher than the surveyor who sets the stakes for the grade checker to utilize. Unfortunately, that's just the way that it is.
Yeah, I have to apologize that I have and concede I have no expertise in that area. Quite frankly, and I don't mean this to be flippant, but in this area, California is in a world of its own. When I have friends who are surveyors in California and owners of surveying firms, and I cringe when we get into discussions about how they do business because they're unionized.
Okay. County surveyor in Kansas, and the people that's working for the surveyor are not licensed. Is this something that would burden the county if we go out and replace section corners on a federally funded project?
Section corner, no, because that's not construction-related activity.
Okay.
And I'd have to do some research, Tim, but I don't believe this applies to government employees when the service is performed in-house by government employees.
Okay.
Specifically, the law specifically talks about contractors and subcontractors.
Okay. It says, I'm looking at the regulations.gov and see a PDF proposed rule with a box that says comment. Do we click on that to make a comment? Any ideas?
I have not encountered that myself. I know you go to regulations.gov and then like a template will come up and you fill it in.
Okay.
That's the most.
Yeah, Tim,
that's the most appropriate
because
way.
we're doing coalition letters with some of the other professional societies we work with, team up with in DC. I have to go through this process and submit not just the NSPS comments, but the coalition comments. So what we've done in the past when we've submitted and gone through the Federal Register portal, you can click there, but there are specific directions on how to do it, and you just need to literally one at a time, because this most likely maybe your first time doing this. If you haven't been to the site before, it's very user friendly. Every time that I've had to go and do it, Tim, it takes me maybe 2 or 3 minutes just to read through the directions and another 2 or 3 minutes to actually submit the document. Typically what you do is you save the document on your your laptop, on your personal computer. And then what you need to do when you submit it is you need to basically copy and paste the letter and or transfer it from your drive onto the Federal Register location where there's like a little drop box.
Okay.
If it's something where you're just typing something in, there are a couple of different ways to do it, but in the case of putting a letter together on your office letterhead and then PDFing it and turn it into a document with your signature, you can do it a couple different ways, but the actual submission process can be done as if you're just typing comments or entering an actual legitimate letter on office letterhead as a PDF. They have different ways to do it. So I would just encourage everyone to read through the actual directions. It's very user-friendly each time I've done it.
But there's not like an email address that you can just send a PDF letter to. You're going to have to go to that regulations.gov. A template will come up. You'll have to fill it out with your name and address and what have you. And then there's a way, as JB said, that you can upload or attach. You can either put your comments in a box or you can attach a PDF. But you're still going to have to fill out that template.
And what's very important is that you will receive a confirmation that it's been entered. So you'll know one way or another whether you've been successful in actually submitting the actual public comment, because typically whether it's not a bounce back, but an automatic email to your email address, if you include your email as part of the submission process, or when you actually place it into the comments, when you hit enter or the actual submission itself of the public comment, typically on that screen, it'll say confirmation received. Thank you for submitting your public comment. And what I'd recommend is that if you have your smartphone available, just take a quick screenshot of it on your computer screen, or take your phone out and take a quick picture that you actually have some version of a confirmation in case you don't list your actual email. But typically when you put your email in there, you'll receive a specific auto-generated response to your email, whether it's your personal or your office email, whichever one that you use when you submit the public comment.
I think your email is a mandatory field on that template, but the important lesson there from what JB said is don't wait until like this time next Tuesday at 10 minutes after 5 to submit your comments. Submit it before then, earlier in the day or next Monday or over the weekend, so that, you know, if you don't get a confirmation, you can go back and give it a second try.
Yeah, I'd knock it out on a Friday afternoon or first thing Monday, May 16th, the day before they're due. That's what I'd recommend. Shoot for this Friday
you can do it
afternoon.
over the weekend. You can submit over the weekend as well. I mean, you can do it 24/7. It just has to be before close of business next Tuesday.
Okay. See back where I was. A couple of questions regards to ACEC, American Council of Engineering Companies. Yes, we are in talks with them. Yes, they're pretty much on the same page, and we'll be coordinating our comments with them later this week. And anything more to add to that, John?
JB and I have been in touch with them as well. They have a group, a special interest group within ACEC called COPS, Council of Practicing Surveyors, and the chairman of that group has been in touch with me. So they are supportive and we are coordinating.
And Tim, I'm happy to say we just picked up another organization to co-sign our coalition letter, the Construction Industry Roundtable, CIRT. They did co-sign the 2018 version. So they are another group that we've brought back into getting the band back together, if you will, as part of a coalition effort.
Okay. How does this affect current prevailing wage contracts, or will it? How will everything that's already in play?
If you have an existing contract that's in place when this, if this rule goes through, now let me strike that. This will not affect you on a current contract unless and until this proposed rule becomes a final rule. In which case there might be an addendum to your contract. And you may either retroactively or from that point forward have to comply. And I would imagine that there would be an adjustment financially if that's the case.
Okay.
But again, this is simply proposed at this point in time. It will not be effective for quite some time now.
Okay. As you've noted, in addition to the increased wages, there's going to be an increased administrative costs, accounting departments, accounting procedures, what have you. Do you know of any type of analysis that's been done on this, the economic impact that all of this is going to have on our profession?
I am not aware of any studies on the administrative costs to individual companies, but that's a great question, and I would suggest that even if somebody can do a back of the envelope estimate of what it means to your firm, I would include that in your comment. But I don't know of any macro study that has been done on that, Tim. That's a great point.
Why do you think this has all become an issue?
Politics.
Okay.
One word answer, it's politics. It's Democrat, Republican politics, it's union versus non-union politics, but this is very politically driven.
Will there be an updated definition of labor if this comes around and gets added to the Davis-Bacon Act?
Well, I would argue that that's what they're trying to do here. They're trying to expand the definition of laborer and mechanic in a way in which there is no precedent and no justification. That's why I'm saying this is sort of an arbitrary and capricious effort on the part of the Wage and Hour Division.
Okay.
I mean, we have made the point, and I did in that where I was invited by the Small Business Administration to make a presentation, and there were the acting administrator of the Wage and Hour Division and two of her attorneys were on that meeting. And the point that I made was if they want to expand the definition of laborer and mechanic, they should get legislation introduced and passed by Congress. And you'll love this one. I said, pardon the pun, but what you're doing here is outside the boundaries of your authority under current law.
What if this would go through? How would this affect the agencies that have capped rates on various employee classifications?
I would imagine those rates and whatever multiplier would be changed.
Okay. If this rule goes through, do we think contractors will be able to perform the work without an LS or PE and responsible charge, or will state law still prevail over within federal contracts?
State law still prevails with regard to the definition of the practice of surveying and what role a licensed surveyor needs to play to satisfy the state law definition of responsible charge. This has no impact on that whatsoever.
Okay.
If in your state law, construction stakeout has to be done under the responsible charge of a surveyor, that's the law today, and that's what it would be even if this is implemented. This is a question of how are the members of the crews classified?
Okay. if I can't make that question out. Would a certification like a CST help create an exempt field staff as being a technician, or rather than laborer, or would that just be unnecessary argument?
That's actually a good question. I did not include it in my presentation, but if you recall on this slide, I talked about precedents where members of survey crews are classified at a level above laborer and mechanic. The same is true of CST. And Tim, you can help me as I'm drafting the NSPS comment about where the CST program is used and recognized by the federal government or District of Columbia. I know here in the Washington area, our Washington, D.C. subway transit system, Metro, CST is a requirement in their contracts. So, you know, even the CST program classifies survey technician as being above the level of, quote, laborer or mechanic. So that's another example of where what the Labor Department is doing here is inconsistent with standard practice in the market.
Okay. Okay, as far as, I mean, we already said if this thing goes through, it'll probably be by the end of the year and then another 6 to 12 months after that. So we're anticipating a final ruling probably by the end of the year?
It's really hard to say. I would say at the earliest.
Okay. Let's see. Well, if all of the crew members are capable of running the equipment and considered, you know, more, you know, intellectual than the labor side, is there any way to do this without having anyone on the crew defined as labor?
Yes. If you go back to the Goldberg standard, to the extent that the survey crew is performing tasks like sharpening stakes or clearing brush, they would be covered under the Act. That is clearly physical and manual labor. And let me say, if they primarily are performing those tasks, if that type of task is a very secondary or minor proportion of what they're doing, they would not be covered under the Goldberg standard. They're not today, because we're still living under the Goldberg standard today. Does that make sense? Is that clear?
Yeah, I think so. And this actually comes from our little shout out to our past president, Bob Don. He says, when Connecticut was reacting to the Fazzino case, I charted prevailing wage as best as possible. I did not find one instance where my technicians were being paid less than prevailing wage. AKA, my people would have been paid less in most cases, if not all cases, excuse me. I consider my employees to be paraprofessionals. Do we have any examples of current prevailing rates for surveyors?
No, that's a great point, Bob, Tim, that Bob makes. And I know that Bob has quite a bit of institutional knowledge on that Connecticut instance. No, we do not have any data, any current data or anything like what Bob experienced. It would be more just what individual firms experience anecdotally.
Okay. Says on the website, where's the link to the past letters promoting this change? I think we had.
Yes, that's on that page. I'll put it up again. Just scroll through that and you're going to find just a plethora of information about this issue. Quite frankly, to brag about NSPS for a moment, I think that when our members look at that page, if they've not done so before, I think our members are going to be impressed by the depth and breadth of what the society has been doing on this issue and how engaged we have been. We've been at this for a long time. I remember when I was working for the old ACSM in the 1980s, it was during the Reagan administration, we got a letter from the Labor Department. I personally was involved in getting a letter from the Labor Department saying the Goldberg opinion still stands. That is the benchmark by which we are operating. And so this goes back many years. You know, Kurt Sumner will tell the story that from time to time, NSPS has gone back to the Labor Department with that same question. Is the Goldberg letter still your point of view? Yes, yes, yes. And the very people who repeatedly said, yes, that's still the standard, are the same people that wrote AAM 212 for the Obama administration. So when you ask me the question, what's driving this? It's politics. Because there's, as I indicated in one of my slides, nothing has changed. It's not like a court has ruled or Congress has passed legislation and that is what drives or necessitates new regulations. Nothing has changed on this issue.
Exactly. Well, here's a scenario that's been thrown out. If a party chief is somewhat considered the intellectual, the brains of the operation in the field, and therefore exempt, but the rodman out there in this case, not running the equipment, is setting those construction points. Party chief's not considered prevailing wage. Labor is considered prevailing, or the rodman's considered prevailing wage. Don't we see an imbalance here to where that guy prevailing wage could be in some cases being paid more than the party chief?
It's possible. It's possible that, I mean, it is possible that that rod person, that instrument person is paid more than the professional land surveyor.
Right. Okay. Let's see. Now that one's not quite exactly what we're after. So is it known as a fact that these wages could be higher for the survey crews, or could we possibly be looking at stuff that's lower? I guess it just depends on really where you're at and what the prevailing wage has been set.
Well, you know, Bob Don's example of what they experienced in Connecticut is that the, quote, prevailing rate is lower than the market rate, lower than what he was ordinarily paying his folks, his employees. So it is possible.
All right. Would an email or would a comment letter be good coming from, this goes back to the county surveyor, coming from the county surveyor or the county attorney? Would either, I'm thinking it'd probably be both.
Yes, both would be helpful. I think it would, given the fact that it's lawyers in the wage and hour division that are primarily going to be doing the technical work on this, if they hear from a fellow attorney and that attorney makes some good legal arguments, I think that would be very persuasive, would carry a lot of weight. So I would encourage that if that's at all feasible.
And I would say that, Tim, going back to John's appearance before the small business panel back in late April, yeah, I mean, the point of that was to hear from small businessmen and women. And the fact that a public official would go on the record against this proposal, that's gonna actually add value to the small business perspective. That we have.
I would also add that to the extent that, because I know we went through this with the AAM fire drill. If anyone on the call is with the Corps of Engineers, the Forest Service, any other federal agency, Bureau of Reclamation, that does construction and does use surveyors as part of those construction projects, if your agency can comment, if you can persuade your agency to get engaged and comment, that would be helpful. I know when we went through the whole drill on the AAM, the Corps of Engineers was a good partner in this and was very concerned about the impact this would have on their program and projects. And you know, if you have other federal agencies that are commenting to the Labor Department saying, you know, you're really off the reservation on this. We strongly disagree with what you're doing here. It's going to adversely impact our agency and our program. That's very persuasive commentary.
And John, you listed a couple of agencies. I don't know if you mentioned it, but National Park Service, they're receiving infrastructure money as well for different things too.
Any agency, I mean, you know, BLM not as much because theirs is more cadastral and not construction related, but any agency that's doing construction or managing construction and has to employ the use of surveying firms would fall in that category. I mean, we could sit here all day and start listing all the agencies, but you're absolutely right. Park Service is another one.
Okay. Just a note here that somebody's chimed in that in California, prevailing wage for surveyors is much higher than standard rates. So that is one, I won't necessarily say exception, but that's one place where there isn't, I'll call it an imbalance for the argument for prevailing wage. If we do send a letter, is it listed who it needs to be addressed to?
Yes, you'll find that at that link that we have in here.
Okay. Is in, okay. All right.
And again, Tim, you're not sending an email to an individual per se. You're filling out an online form. So it's already pre-programmed that it goes to a particular mailbox.
Okay.
It's a template form online.
All right. And then we do have one gentleman from California, Mr. David Woolley. I'm going to unmute him.
David is an expert on this, and I worked very closely with David. Had a chance to meet him in San Diego a few years ago. We worked very closely when the AAM came out. So David is an expertise, but I don't mean this for any disrespect to David or anybody else, but you know, you heard the old expression about the tail wagging the dog. In this case, California is the tail, it's not the dog, because it is the exception, because surveying is unionized like no other place in America in surveying.
David, you are live, so have at it.
Hey, John, good to see you again.
Hello, David.
Yeah, I just want to give you a sense of how California is, and I do understand it's unique. Most places aren't subject to operating engineers, but the impetus came from Operating Engineers Local 12, which is right here in my backyard. I've worked with operating engineers all my career, and we've worked cooperatively for the most part, but I want to give people a sense of how they're different than how we function. And if you let them in through this process, it's only the beginning of it. So I'll give you an example. Prevailing wage right now for somebody in California is about $80 an hour. It ranges from $78 an hour to $80 an hour. And so I have a 23-year-old college student, and I pay her $77 an hour with 1 year experience because that's how it goes. That's prevailing wage on this job. We don't distinguish between chainman and party chief and these kind of things. I understand what John said, but that's not really how it works here because you're immediately on the defense to talk about this. So I have historically always had licensed party chiefs within our firm, but I still have to pay prevailing wage across the board. Now, California has statutes that are that way, but these were enacted by Local 12. And what they do is once you become a laborer and mechanic, then what they do is they're going to go in and they're going to start modifying the definition of a land surveyor. And so that definition broadens, and so you have more covered crafts. In California, with the latest definition, it includes drones, it includes 3D laser scanning, and the idea of topography and boundary and these things being relegated separate, it doesn't really work that way in California with us because you're subject to prevailing wage because there's federal funds and they don't really separate it out. So the union will come in and they'll do an audit and they'll say, well, these guys are surveyors, they're a covered craft. And it's on the burden of the employer to come in and say, well, no, but we're doing boundary. And they're saying, yeah, but boundaries in preparation of construction. You're not just doing boundary like forest work, for instance. You're doing boundary because they want to know where it is, so you're going to build something. And so they start roping this in. So that's kind of how it works, and so that definition is going to evolve. I don't think there's reasonable expectation that it will stay with chainmen or laborers because they'll start modifying it. And the reason that they drove this out of California was because of the federal enclaves. So what happens is everybody is subject to prevailing wage with public funds in California in most circumstances, but federal enclaves such as Camp Pendleton in our neighborhood, they have no jurisdiction there. So they being operating engineers, didn't like firms coming in to the federal enclaves and not being subject to prevailing wage. And once they get this prevailing wage tied to the projects, then it opens you up to project labor agreements, which means you have to integrate union staff with your staff at 1-for-1. So you're paying your person in California $80 an hour, and you're integrating in somebody that you don't even know at another $80 an hour into your workforce. If you're laborers, that is a logical step, is these project labor agreements. If you're a professional, you're completely out of that realm. So this is only a building block to open the door. And I can just tell you how it's worked out in California, and that's how it works. Now in LA Basin, we're very fortunate to be distinguished as a top QBS firm. But what distinguishes us more as a firm is when they do multiple qualification-based selections contracts, our firm is the only firm that is usually in that list that isn't signatory. Everybody else is signatory because if you say how much paperwork is it, I've had Local 12 auditors in here for 4 hours, 4 times this year, 16 hours of them in my conference room. And that's also occupying admin staff to go through these audits to make sure all of our paperwork's in there. And it gets more like that. Now, how they determine prevailing wage isn't like a survey like we would imagine, like we talk to 10 people and this is the average or this is the median. How they determine prevailing wage is they use a mode, is what they call it. And what a mode is, for anybody with the math skills, is the mode is the most reoccurring number in a given selection set. Well, in California, we have about 1,100 signatory members that all make the same wage. Therefore, they are the mode. And that's $80 an hour. And so that's how they determine prevailing wage is a mode. So the unions will come in and they'll say it's determined by the mode. And so most non-union firms paying prevailing wage are actually paying, my employees, my field staff make more than I do as a principal when they're on a prevailing wage job. My out is about $850 an hour just in wages. $150. So that kind of just answers some of those questions about how they determine it and then in California is different. But the current labor secretary is a gentleman by the name of Marty Walsh out of Massachusetts, former governor. His deputy labor secretary is Julie Sue, the former labor secretary of California. She is very well versed in all of this. She knows how this works, and she has these relationships. And so I understand that in Kansas or, maybe some of these other places, it seems like maybe different than it is, but I'm telling you, I've been in this for 30 years plus, worked very closely with Local 12, don't really have a beef with them, but I'm telling you, this is how it goes. And it's that modification, get the foot in the door, change the description of what it is they do so that you open up a bigger umbrella. Then you create this burden through this auditing process and through this process so that a non-signatory firm, it's a laborious thing to do. And so that's just a on the ground perspective of how it actually works here. And to give you one last thing is California has about 4,200 licensed surveyors. We have about anywhere between 1,000 and 1,100 signatory people who are actually members of the union that are hired by survey firms. So we outnumber them about 4 to 1. You get your technicians and your LSITs and your CSTs and all this. I'm going to just estimate we're about 10 to 1, but they run the show with that 1,000 people. And that's how they do it, is they modify that scope. And I really appreciate the time. That's all the questions that you ask, and that's just me on the ground telling you nobody sharpens stakes here. Nobody does any of that work that they call labor, but they run the show, and that's what I'll leave it at that. And thank you for the time.
David, thank you. I just want to put make two comments on David's perspective. One is he offers a very valuable perspective about, sort of the camel's nose under the tent and how this becomes a slippery slope. And I think that's valuable. But I do want everyone on the call, I did not want to get people confused about the California situation, because part of what David just described has to do with the union contract as opposed to your contract on a project that has federal funds. So they're really two separate things, but the ultimate impact has some similarities.
All right. Couple more questions and we'll see about wrapping this up. Do these classifications / definitions affect any liability issues for the construction companies and contractors, where if they don't have land surveyor involvement? Any thoughts on liability?
That is outside of the scope of these rules and this discussion.
Okay.
Again, you should discuss that with your insurance carrier, and you should discuss that with your licensing board as to whether that practice would be permitted in your state or not. But that really is not part of this particular rulemaking.
Okay. If there's a chance that this does pass, do we think it's going to basically become down to one prevailing wage for surveyors, or do you see it being broken up depending on expertise of that field surveyor?
I'm going to give you an opinion here, not something based on fact, but my opinion is based on past practice, particularly of what we saw during that period between the Obama AAM and then finally when Trump repealed it. You're going to have very generalized job titles, so it's not going to go down to, rod person, instrument person, and so on. It's going to be a very broad category, and as I said before, it may not even be a surveying category. It may be a construction helper, which means 100 different things, one of which is some surveying function. So I would expect a very broad general category and wage rate, not something very specific and granular.
Okay. I think of everything that's come through. That's about it. There's a lot of doubled ups.
Let me add one other point, Tim, while you're perusing those to see if there's anything new.
Please do, yes.
When we went through this exercise on the AAM, we uncovered a video that the operating engineers submitted to the Labor Department that sought to portray how survey crews function on a construction project. Number one, that video is no longer available on YouTube. I think the operating engineers got sort of a black eye by advocating with that it was so distorted and inaccurate. It showed a crew of 8 or 10 people. That there was one person who took the instrument out of the truck, another person who carried the instrument to the job site, another person who carried the tripod, another person who attached the instrument to the tripod. These are the class of workers that the operating engineers utilize, and they were trying to convince the Labor Department that that was the common way that surveying is performed. Well, there's not a private surveying firm in America that does business that way. And I think that's the reason why that video is no longer available. It was a gross distortion and tried to show that these people truly are laborers and mechanics and not the paraprofessionals, to use the term that David used a moment ago, not the integral part of a professional surveying function that the members of our crews carry out typically and predominantly.
Okay, let's see. Yeah, Mr. Don made another comment. In his current practice, the party chief sets the stakes. If this were to pass, I would suggest 2 wage rates: surveyor licensed and surveyor unlicensed.
No, I'm not sure we want to go there because the surveyor license is exempt.
Is exempt?
Exempt. Yep. As is a party chief.
And another comment from Mr. Woolley. This is how Local 12 describes field surveyors. No judgment or discretion in executing directions of the office surveyor.
There you go. That makes the case that that may be who the unions are talking about. That's not the reality of practice. That is a laborer or mechanic. That is not what typical survey crew member is doing in today's economy. But Tim, what I'm going to put in the draft, and obviously it'll finally be up to you and the officers of NSPS, but the point that I believe NSPS should make, and I will put this into the draft that I prepare for you, is to simply say to the Labor Department, strike what's in the proposed rule and simply restate what Secretary Goldberg said in 1962. That members of survey crews are exempt from the Davis-Bacon Act to the extent that they are performing work that is primarily intellectual, judgment, and analytical in nature, and that it only applies to the rare instance in which a worker is sharpening stakes or clearing brush and solely performing manual labor, period. That's what ought to be in the final rule.
Okay, very good.
So we're going to offer an alternative, not simply say we're opposed to this,
Exactly.
but offer an alternative and say that there is a standard that has been well accepted for 60 years. The only question has come from the very limited unions that are involved in surveying in the United States, and that this is a settled issue for 99% of the surveying market in America, and therefore it ain't broke, so don't fix it.
For someone to go out and see what the current prevailing wages are for their state, for their area, any tips besides go to Google and say prevailing wage, middle of nowhere? I mean, who typically houses that information?
That is by the Wage and Hour Division, the very people that are writing these rules. That's who promulgates those. The Wage and Hour will do whatever their methodology is. They'll come up with a wage determination document. They will send that to the procuring agency, and then that agency will send it to you as part of your contract. I don't know off the top of my head, other than doing that Google search, where you would find them. I don't recall if they're housed in a particular place. But again, as I stated a couple of times previously, what we found, again, during that period where the AAM was in effect, you did not find a wage rate for, quote, survey crew. You found some generic, construction helper.
Right.
David may remember some of these because I know he and I looked at some of these. But they were very alien and not accurately descriptive job titles. And I know we had NSPS members that came to Kurt, Tim, your predecessor, or came to me and said, figure this out, help me with this. And the answer was, the Labor Department is just not getting down to that level of job title, and this is the one apparently you're going to have to live with, as imprecise as it is.
Right, and I think that was another statement by somebody else that jumped in and said, not been able to find it for for a surveyor for their area. And you're right that if it hasn't been culled down to that surveyor and been determined, you're right, they're going to find something the locals feel like they're equivalent, and it's going to be thrown under general labor somewhere.
Right.
Mr. Woolley, you want to jump back on for just a second? You said you had something else on trainees, which is a good point.
In this same proposed regulations, they want to strike the word trainee. And that's going to be problematic for us because what they're trying to do is isolate it and create an apprenticeship, which is exclusive. Apprenticeship is a defined term, and it's offered by the unions. And so what they're trying to do is isolate and funnel us through to apprenticeship programs. And we see that in California. And for most places that don't have signatory firms, you don't want that apprenticeship requirement. You want to have trainees, and apprentices are staging process. So I think we should probably put our hand up and not want to be part of the trainee, not strike that word trainee.
Very good.
Yeah, that's particularly with our CST program at NSPS, because like in California, the NSPS CST program doesn't meet the criteria to be an apprenticeship. Even though it's a federally accepted apprenticeship program, it doesn't meet the California criteria, and so we can't apply it, which is a shame because we don't have enough hours. So that's just another thing, and thank you guys.
One comment from Mr. O'Brien, a signatory firm. Help explain what a signatory firm is in context with prevailing wage and the unions.
This is why I really did not want to go down that, pardon the pun, that rat hole of California, because I think our members are going to be confused. A signatory firm is a firm that is unionized. Period. So it really is very different than the Davis-Bacon Act discussion. The firm has signed a union contract for its employees.
Go ahead, David.
I was just going to leave everybody with an interesting assignment if they don't know. John's exactly right. Davis-Bacon started in 1931, but I think members, professional members that this group is, you should look at the history of what Davis-Bacon is. It's actually the last remnants of redlining, and it was just, members, read that. As professionals, you would be amazed that this is still lingering. So just Google Davis-Bacon history. Good reading lesson for us.
I'll give you a 30-second history. It's a good note to end this on because it shows how antiquated and superannuated or out of favor with the current times this law is. Davis and Bacon were Republican members of Congress, one at least from New York. During the Depression, there were obviously construction contracts are on a low bid basis. Construction contractors from the South were bidding low on construction projects in New York. And the reason why they were bidding low is they were using cheaper African-American labor from the South and transporting them up to a project site where they won a contract. Davis-Bacon said, that's terrible. We don't want these African-Americans from the South coming up here and taking jobs away from our people. So we're going to write a law that says that the local prevailing wage for the locality where the project is to be constructed will apply. So it was an attempt to level the playing field to discriminate against African-American labor from the South. And believe it or not, that law is still on the books today. So it's a very different economy, a very different market, a very different way of doing business, very different country socially, but the law endures. So that's that history that David was referring to.
Okay, very good. Well,
on that cheerful note, Tim.
Let's see. Question: if we're going to do another live version of this anytime, this is being recorded. We're going to I'll get this posted up with the PowerPoint on the website. We'll also, this will be in our news and views. I will be sending out a link to all members, just a special email where people can find this as well. Bottom line is, I don't think we need to go through another live and rehash it again, because I think all your questions were very good today, and I think we covered pretty much the bulk of it all. And unfortunately, we're also running short on time for next Tuesday. So let's get this out. Let's get this. Let's get everybody as much as we can informed, and we'll see if we can together we can make a difference.
Well, Tim, thank you for doing this. Thank you to all the NSPS members that participated. I hope this was informative and helpful to you. And again, we encourage everyone to submit comments before next Tuesday.
All right. And
thank you.
With
and
that,
on behalf of JB and myself, again, thank you for the honor and pleasure of being your government affairs consultants and working with NSPS. We're passionate about it and we enjoy it.
You bet. Appreciate it. Well, thanks for helping us fill up the entire 2 hours. I didn't think we were going to have to, but you know what? That's okay. That's what we're here for. So, John, JB, thank you for being on here, putting this together, and we'll be back in touch very soon.